Good afternoon and good morning, depending where you're calling in from. Thank you for joining our webcast today. I'm Jonathan Edelheit, President of the Healthcare Reform Center and Policy Institute, and I have one of our healthcare reform experts on the call, Ben Conley from Seifert Shaw, and also Terrell Bagwell from WorksTime. And it was definitely really good timing in regards to today's webcast, because we're going to be covering that kind of exciting and controversial update on from the D.C. Appeals Court on the Obamacare subsidies in the federal exchange states. So Ben is going to be covering that, and I want to thank Ben for whipping and putting that together on such short notice to include it in this webcast. So this is part of our healthcare reform updates for our certified healthcare reform specialists. And also our Ask the Experts. And we also have James Napoli on the call from Constangy, both two of I would say the top experts in healthcare reform out there. So one of the nice things at the end of the webcast, we'll be able to do our Ask the Experts, where you can ask any question that you want, and at any time you could also start typing those into the Q&A section. So wanted to give you just a couple exciting updates in regarding, specifically for our CHRIS students who are certified in healthcare reform. We've had thousands of CHRIS students who've gone through our certification who definitely stand out from the crowd. And I want to, really thank our instructors, Ben and Jim, and, the others who make our program really so amazing. One of the reasons why it really, is a real differentiator is it's because of who the instructors are. The national legal experts who are in the trenches each day, up dealing with the Supreme Court, HHS, DOL, IRS, and having, key people from the Obama administration, HHS, IRS, DOL, providing key content in their course. And some of the new updates we're having going forward, and a very big focus we're going to have going forward, is in the audit preparation, litigation avoidance, and compliance. And I'm really excited to announce that, if you're not in one of our LinkedIn groups, we're now the largest influencer for HR and insurance executives in the industry. We reach about 500,000 members in about 30 different groups on LinkedIn. We're adding about 3,000 to 4,000 per week, and we reach now about 300,000 HR professionals and executives in our different groups. And one reason I mentioned that, if you're not focused on LinkedIn, what we run, for example, one of our groups, our Healthcare Reform LinkedIn group, which has about hit 30,000 people today. This is where everyone gets their updates and news now, is LinkedIn. So, we did a survey about 5 months ago, and, both HR execs and agents said they get the majority of all their news and updates from LinkedIn and no longer from trade magazines. I'm also excited to announce our partnership with the HR Professionals Association, which reaches almost, has almost 200,000 members. And we've created a partnership with them for healthcare reform education. And we're going to be doing a big branding campaign this year with human resource professionals and executives for those of our professionals who've gone through our Certified Healthcare Reform Specialist program. So, they're endorsing that program as the official program, and for HR to only work with agents and brokers and consultants who have been certified as a CHRIS professional. And they're also, we're working with them, and they're going to start giving out free passes to their members who are HR professionals to attend our annual Employer Healthcare and Benefits Congress and Healthcare Reform Conference, so we can really network with them, with our CHRIS students. And then next year, they're going to be building out their annual conference within our National Healthcare Reform Conference and Employer Healthcare and Benefits Congress. So I think you're going to see a really big dynamic change with our annual conference with significant growth. And I'm really excited to start really promoting our CHRIS students to this large group of people and helping them connect with more HR professionals who need guidance and advice. And I think as Ben goes through, some of the updates today, this is going to be where, the employers need a lot of guidance and advice and a lot of comfort. So real quick before I turn it over to Ben, I hope to see everyone in a couple weeks at our conference. It's September 20th through the 24th in Washington, D.C. We got over 200 speakers. If you're on the call and aren't certified, you can get certified at the conference. You get continuing ed credits for agents and SPHR credits for HR professionals. And, we have the IRS coming to speak, DOL, HHS. These are examples of some of the quality speakers we've had in the past. We bring in all the national employers to present case studies and what they're doing in healthcare reform and other areas like corporate wellness and self-funding. We had about 2,200 attendees last year and grew about 40%. So on track to do that again this year. It's really an exciting event. It's all based on education, certification, and networking, kind of like the way conferences used to be in the industry. If you are a CRIT student on the call, we're kind of rolling out the red carpet for you this year, where if you'd like to attend, you can get a discounted rate of $500. And that includes your continuing education credits. So you basically end up saving about $600. And it's the code is CRITGETCE, and you can use that at the employerhealthcarecongress.com. And if you are not certified, definitely encourage you to. And you can get, we have a special promotion right now. If you can get certified, and they get a complimentary pass to the conference. So it's $995, so you save about $1,000. And that code is 14CERT. So with that, I'm going to turn it over to my esteemed colleague, Ben Conley. Ben, it's all you.
Thanks very much, Jonathan. And I'm going to mix things up here a little bit and jump down to a slide later in the presentation here, which I imagine will be of interest to the folks in the room, more so than the other updates, which are definitely interesting, needless to say. But before we understand the mechanics of the employer mandate, I think it's probably more important to understand whether the employer mandate is really relevant anymore. I think it is. We'll get into that discussion a bit, but I got to say the timing of this webinar was pretty amazing because it started about an hour and a half or 2 hours after this decision came down, which was originally Halbig versus Sebelius, now Halbig versus Burwell, the new Secretary of HHS, ruling on the issue of the availability of subsidies on the exchanges. Typically, late-breaking news is a great thing for procrastinators like me because you haven't even started on your presentation anyway. But I thought I'd put off my presentation to the last minute, sending it over to these folks at 11 p.m. last night, but apparently I didn't wait long enough. So I scrambled to pull together this slide, which I think will be a helpful illustration, but haven't had a chance to pull together much more, so you'll just have to work with me through my rambling thoughts. So the decision of Halbig versus Burwell dealt with the issue of whether tax credits should be available on exchanges that are established by the federal government. So just back to ACA 101, the ACA mandates that all states establish an exchange, but if they fail to do so, the federal government will come in and set up an exchange on their behalf. Now, the way the law was written, it was anticipated that more states were actually going to establish their own exchanges than what ended up happening. And I've got the map up here, as you can see. Ignore this maroon, that should be a red. But what this generally shows is that the vast majority of states either fully deferred to the federal government or deferred in large part to the federal government to establish an exchange on their state. So that's all the red states and all the yellow states are potentially impacted by this ruling. Now, what this ruling specifically challenged and what it could result in is that the way the law was written, it said that tax credits to help people pay for the cost of coverage on the exchanges would only be available through exchanges established by the state, which are those states on here that are green. Now, when the IRS issued regulations, they tried to clean this language up, which was viewed by many as sort of a typo in the law and not reflective of the intent of Congress that its subsidies only be available on the exchanges established by the state rather than those established by the federal government. So the IRS cleaned it up and said actually what Congress meant was that all states are eligible for tax credits. So what this means is that generally speaking, when an individual goes to the exchanges and they get a tax credit or a subsidy, that helps them pay for the cost of that coverage. More broadly speaking, the employer mandate itself is directly linked to an individual's receipt of a tax credit and subsidy because even if the employer offers coverage that is totally non-compliant or doesn't offer coverage at all, if none of their employees go out to the exchanges and get a tax credit, that employer will never be directly penalized. So this is all sort of linked together. Obviously, the individual mandate as well. You can satisfy your obligation on the individual mandate by getting coverage on the exchanges, among other places, but that coverage on the exchanges could be 4, 5, 6 times more expensive, absent those federal subsidies to help pay for that coverage. So this decision has potentially broad-reaching implications. So the way the law was drafted, it was very narrow in that it said that tax credits are only available on states or exchanges established by the states. Various lower courts had weighed in on this and by and large ruled that congressional intent was that tax credits be available on all of the exchanges. And the D.C. Circuit notably at the lower court level held the same. So the decision that came out today, which is a pretty lengthy opinion that I haven't had an opportunity to work my way all the way through yet, but more broadly said, we disagree. The law was written consistent with congressional intent, or there is not sufficient evidence that Congress intended it otherwise. So our ruling, despite the fact that it has broad-reaching implications, is that Congress didn't intend for there to be tax credits available on the federal exchanges. Now, a couple important takeaways from this ruling. Number one, it is not immediately effective. The circuit court overturned the lower court decision and remanded the case to the lower court with a directive that the lower court enter a judgment that subsidies are not available on the federal exchanges. What we anticipate will happen before that actually takes effect is that the Obama administration will appeal to have the decision heard en banc by the D.C. Circuit Court. So rather than 3 justices hearing the decision, all 11 justices, I think, will hear the decision. Now, here's why that's notable. Number one, it'll slow down the process, right? So the remand to the district court level will likely be put on hold, and the law will remain status quo pending the outcome of that ruling. Number two, perhaps it was just a coincidence, but out of the 3 justices that struck down the decision today, 2 were Republican appointees and 1 was a Democratic appointee. I'm sorry, 2 were Republican appointees and the 1 dissent was a Democratic appointee. So the decision did break down along political lines. If you look to the broader D.C. Circuit, and I was just looking at this information this morning, 7 of the justices on the D.C. Circuit, if it were to be heard en banc, are Democratic appointees, while only 4 are Republican appointees. So, again, not saying that it's going to break down along those lines, but if the ruling ultimately does break down along political lines, the likelihood is that the en banc decision will come out the other way. Also, as I mentioned, there have been challenges to this law in other circuits, and while I haven't been able to verify this, and I was just reading about this right before hopping on, there are conflicting reports coming out that suggest that another circuit court has, in fact, held the opposite of what the D.C. Circuit held and ruled that it was the intent of Congress that the subsidies be more broadly available on all exchanges, regardless of whether they're set up by the states or the federal government. So what that likely means is that what you're going to see is that the Affordable Care Act, or at least this component of the Affordable Care Act, is once again going to be run up to the Supreme Court, who very likely could put off the decision until June of next year, or even later for that matter, before we actually get the final word on the outcome of this significant component of the law. Now, this will be the 3rd time that the law more broadly has come before the Supreme Court, and each ruling has had different levels of significance. So the first ruling was significant in that the attempt was to strike down the individual mandate and the employer mandate, which, without getting into too much detail, most observers agreed would derail the law. Also, the law was being challenged from a severability aspect, meaning that if one part of the law is unconstitutional, the entire law is unconstitutional, and the court did not reach that decision. So while there was a limited impact from the first decision on the Medicaid expansion, It wasn't more broad-reaching. Obviously, the Hobby Lobby decision came out about a month ago now in June, and that decision, while it got a lot of hype and a lot of press, actually addressed a very narrow component of the Affordable Care Act, and that is contraceptive coverage, and just for a small subset of employers. So again, that decision cut against the Obama administration and the law more directly, but didn't have broad-reaching implications. This challenge does have the potential to have broad-reaching implications because there's a lot of window dressing in this law, but the meat of it, the 2014 originally, now 2015 component, is sort of all intertwined to this specific issue. So at present, I think the answer is, or the takeaway is, yes, this is a surprising ruling perhaps to some, perhaps not to others, but no immediate impact, so still sort of a wait-and-see approach. And I don't necessarily think that I would hedge my bets on this law being more broadly overturned. You know, while the Supreme Court, where this probably will end up, does have a 5-4 split from conservative liberal justices, as we saw with the 2012 challenge to the individual mandate, the justices on the court don't necessarily vote along their ideological lines in every respect. So wait and see in that respect. More broadly, if the subsidies are struck down on federal exchanges, there are, as you can see from this map, still a handful of states, 14 I think, that have state exchanges. So what you might see, you know, Jonathan beforehand jokingly suggested that all employers were going to move their operations to the states highlighted in red on this map. I don't know if we'll see changes that drastic. And, you know, joking aside, even if you are an employer that resides in one of those states, the liability directly hinges on whether your employees go to an exchange that does have subsidies available. So you have to be confident that all of your employees are within those those borders of your state and are not eligible for an exchange tax credit on another state. I think what you might also see coming out as a result of this, if the decision were once again to be upheld and ultimately strike down the tax credits on the federal exchanges, is that you might see some of these states that went with the partnership move more towards a state-based exchange. So for instance, the state that I call home, Illinois, is by and large a supporter of this law. They've taken, where there have been options available, they've taken every step or every action to move towards implementing the law. That being said, I'm just going to put it out there, Illinois is a little dysfunctional, and they realized that they would not be able to establish their own state exchange, at least not to do so in a timely manner, so they elected to do a partnership. So if you see this decision being upheld, you might see some states like Illinois move towards establishing their own state exchange so that they can take advantage of and make available to their residents those generous tax credits. More importantly, I think what you're going to see is that this will potentially come back to Congress. If the law gets struck down, the pressure is going to mount for Congress to do something else to try and address the problems that we're facing our healthcare system prior to the passage of the Affordable Care Act, and frankly, many of which still haunt our healthcare system, including spiraling costs. Now, you would think that with such a pressing problem, Congress would take action to do something, but you know, there was an overwhelming consensus that there was a problem with the waiting times in the VA healthcare system, and I just read this morning that the legislation intended to address that problem has been derailed to a certain extent. So it remains to be seen. Also, you know, as I was discussing with Terrell before the call, you know, the longer that this law lingers, it appears it is becoming more popular. And similar to Medicare, which wasn't popular at the time of passage, with any entitlement program, the people who are stand to be the benefit from that entitlement program, if they like what they're getting, they don't want it taken away. Now, you can dispute whether individuals actually like what they're getting through the exchanges, but a lot of folks who didn't have access to affordable health care coverage previously now do. So just to discuss, just to throw a few statistics out there, just to show the broad-reaching nature of this decision. 8 million signed up for coverage under the Affordable Care Act health exchanges. and 5.4 million of those were through the exchanges. Of those, 4.7 million, so more than half of the folks who signed up were eligible for a subsidy. So that 4.7 million, those 4.7 million individuals are the ones who are at risk of losing the subsidies as a result of this decision. So the thing I want to stress, I guess, is that this is an important decision because it doesn't just impact individuals who have subsidies on the exchanges. It has the potential to have more broad-reaching implications both for the employer mandate and for the law as a whole, although I think it's far too early to write the obituary for the Affordable Care Act at this point because there are a number of things that have to happen for this decision to ultimately derail the law. Okay. I do want to take a step back now and walk through some of our previously planned material, which is to address some of... Yes, yeah,
Ben,
absolutely.
I apologize to interrupt, but
no problem at all.
I was wondering if we could let Jim talk a little bit about the update that you just went into, and then I thought also maybe we might get a little like CNN or Fox News debate going on between you two guys.
Absolutely.
Are you there, Jim? Jim? I feel like we're on CNN and you got the reporter in a far destination. Okay.
Sorry about that. I had my phone on mute. Yes, I think Ben did a really good job of kind of summarizing the case and the implications. A couple things that I would point out, though, is number one, this showdown was anticipated as far back as 2010. When we really saw there's really a few places where the Affordable Care Act can be challenged. One is in Congress itself, the other is in the courts, and the other is at the state level. So if you look at the map that Ben prepared and you know what he was saying, for example, with respect to Illinois and the way that that state has decided to approach the exchange, one could argue, and if we saw the transcript, I would not be surprised if this was argued at the D.C. Circuit level, is that really Congress, in drafting the statute the way that they did, it was not a typographical error. What it really was allowing the states some level of autonomy on making the decision as to whether the state wanted to fully embrace the Affordable Care Act by way of providing their own exchange and then receiving the federal subsidies, the goodies, if you will, the carrot for providing that exchange, or if the states wanted to opt out of the Affordable Care Act in a way by way of not providing their own exchange. And you'll notice that the map, if you go back to 2010, 2011, when these decisions were being made at the state level as to whether or not to support an exchange or sponsor an exchange, most of the red states were Republican-dominated states where they had a Republican legislature or a state legislature or a Republican governor in office at the time. So in some respects, it's not surprising. And I could see, if this were to go all the way to the Supreme Court, I could see the justices in a 5-4 upholding the circuit court's ruling, saying that, you know, statutorily it's the correct answer, and this is something that is left to the states. So it's not that the Affordable Care Act itself would implode absent the subsidies through the exchanges that are federally facilitated exchanges. It would just mean that the debate now goes from Congress to the states. Texas, Florida, Ohio, some of these red states, to see whether or not, you know, the state now will step up and put in its own exchange. And the other differentiation here that I would want to make is this is a very important case, and it does, in essence, gut the employer mandate if the D.C. Circuit's opinion were to become the law of the land. But that being said, it's not that it can't be remedied, because again, like I just explained, it can be remedied at the state level, and there's also no issue of severability or whether the Affordable Care Act itself implodes, because this is not, unlike the first case, the case we had back in June of 2012, where the individual mandate was being attacked, the severability issue there, that was all based on constitutional law. There was a constitutional challenge made to the individual mandate, and then the question would be, had the individual mandate been struck as unconstitutional, could the rest of the statute survive? That's constitutional jurisprudence. This is statutory interpretation. It's different. There's not a constitutional challenge per se. It's more of a challenge that the IRS overreached in its interpretation of the statute. So it's a statutory interpretation case, meaning the issue of severability, should the Supreme Court hear this case, should the Supreme Court uphold the district court's, the circuit court's ruling, there would be no question of severability because, again, this isn't a constitutional challenge. This is one where the court would be tasked with interpreting the statute itself. And in doing that, I can see where some justices might look at this and find great comfort in the fact that, yes, I can read the statute in a way that the D.C. Circuit Court has read, where it really doesn't mean that's the end of Obamacare or the Affordable Care Act. What it means is the battleground, if you will, has shifted from the federal to the state level. And I think conservative justices will find comfort in knowing that they can rule favorably on the statutory interpretation without necessarily destroying the act altogether, which was something that one piece of learning we did get from the first constitutional challenge, and that was the justices in the Supreme Court mentioning that, to the extent you can interpret a statute in a way that saves it, again, that was constitutional jurisprudence. Constitutionally, that's what the court ought to do. Well, here you can, the read that the district court, the D.C. Circuit Court has made doesn't mean an end to the Affordable Care Act. It just means that there's going to be a lot of pressure at the state level, again, assuming that the case survives and the ruling becomes the law of the land. The battleground will be at the state level, and that will be interesting because I agree with Ben that there is not going to be any action taken at the federal level within Congress on this. We still have a House divided, if you will, the Senate being controlled by the Democrats and the House by the Republicans, and I just don't see the Republicans voting for any legislation that would overturn this particular case. And that's, sitting here in D.C., we hear a little bit more about, what's going on inside the Beltway, and that's kind of where we're at. We're at a checkmate, stalemate, if you will, on the Affordable Care Act within Congress. I think if this case remains and is upheld and ultimately becomes the law of the land, we're going to see the battle switch from the federal to the state battlefield, and we will see a lot of pressure. As Texas may receive the pressure from the public to support a state exchange, so too may California, on the other hand, feel a lot of pressure from employers to go to a federally facilitated exchange, because now those employers in California arguably are at a disadvantage to those in Texas, because the California employer has to deal with the California employees, deal with this potential tax or shared payment under the Affordable Care Act, where the employer in Texas who has Texas resident employees does not. So there's an additional expense there.
Yeah, and I agree with everything James said. I mean, the one thing I might disagree with is whether the justices viewed this as simply shifting the battle to the states. There was some pretty strong language in which the justices, said they reached the conclusion with reluctance, and their decision has major consequences, and has the potential to impact millions and millions of Americans. It sounds to me like they understood that they were dealing a potential death knell to the overhaul of the healthcare reform system. I do agree that that's technically not what would ultimately happen, but with the way that things stand today and the makeup of Congress, I find it hard to believe that that the Affordable Care Act would sort of move ahead with the full weight that it was otherwise intended to be set up with. The other thing is quite often what you see happen in these cases is that justices will say, well, look, we're going to go with what the law says and kick it back to Congress, and then if Congress decides that they disagree with what we think the law said, they can fix it themselves. A good argument and a good approach, I think, except that this Congress is a much different Congress, obviously, than the one that passed the law in 2010. So it remains to be seen whether you're really going to get the true intent of Congress if you kick it back, or the Congress that passed the law if you kick it back now.
Well, one thing I would add to that, and the reason that I think that there is a viable legal theory on the idea that Congress intentionally drafted it this way in order to put the true decision making on the states, is there was a theory being floated out there. Again, this is while it was being debated and when we were talking to some of the policy wonks that were looking and crafting the statute, is if the federal government put the mandate squarely on the states and required the states to play themselves and provide a state exchange or somehow penalize them, that there may be a constitutional issue with that. So there's this thought that this is the compromise, and that took some pressure off of the constitutional issue with the federal government dictating to the states. Now, again, whether the feds would have ultimately won or not, that we'll never know, because that issue is not before the court and will not be before the court based on the statute that was ultimately passed. But this is just one where I can see, if you're looking at it from, let's say, a Republican point of view or the conservative justice point of view, yes, it definitely will have an impact, and it means that the Affordable Care Act won't be administered the way that some may have thought that it should have. But at least there's the logical point of reference and the logical comfort in knowing that, it doesn't, I'm not striking down the Affordable Care Act itself. I'm merely saying it's up to the states to ultimately decide whether they are going to sponsor an exchange, and their residents then will have the availability, have these federal benefits available to them. Isn't that what we thought about with Medicare and the expansion of Medicare? It was ultimately the state's decisions, and as a matter of fact, the Supreme Court said you can't penalize the state for not, expanding Medicare. So it's that same type of logic that the conservatives have used in other instances that I could see getting them to the point where they feel comfortable saying, listen, the statute says what it says, and now it's up to the states to decide whether they're going to expand the Affordable Care Act, in essence, to cover their residents or not.
And two final questions for you, James. Number one, when do you anticipate we'll have some if you had to guess, when do you anticipate we'll have some clarification on the issue? I'm going to put it to you to give me a month and a year. And second, if you are an employer who is gearing up for your 2015 benefits offering, how much does this decision influence your approach going forward?
Yeah, those are two great questions. I mean, I'll start with the second question first. If I'm the employer, I would suggest that you prepare as though the act is going to move forward absent the D.C. Circuit Court's ruling. There are a couple, as Ben said, procedurally, there's going to be an appeal for a hearing en banc, so before the entire circuit. After that, there will be a remand, and then there'll probably be, depending on how it goes, there'll be an appeal to the Supreme Court. But it's just like, in litigation, something that I do as well. You have to prepare for a case like it's going to go to trial, even though 90% of them settle, 90% or more settle, but you still have to prepare for it to go to trial, just in case, it does. I think as the employer, you still have to prepare as though you are going to be subject to the employer mandate. Many employers have employees who reside in the green states, if you will. So it's, as Ben said, you're only protected under this ruling, assuming that the ruling becomes the law of the land, if you are in a red state and all your employees reside in red states. Otherwise, you're still going to be subject to the employer mandate. So I would prepare as though I'm going to be subjected to the employer mandate. And if it turns out that the court rulings go in my favor as an employer, I happen to be in a red state and all my employees are in red states, then that's a good thing. I spent some money, yes, in preparing myself, but it was money well spent because I would view it more as an insurance policy right now. Because if I do the opposite and I sit back and I procrastinate and 2015 rolls along and we still don't have an answer on this question, which we very well may not, then I am in harm's way of being penalized and having to pay a penalty, and it's not good enough to say, well, I was waiting to see how the courts would rule on this. And there'll be a question as to whether any ruling in the future would have retroactive application. I think it would be very difficult in this case to have retroactive application, because that would basically mean you'd have to somehow have the federal government go back and seek reimbursement of the amounts that it had paid by way of subsidy from the various individuals. So it's probably going to be a case that will have prospective application, which means if the Supreme Court doesn't get this until 2015, doesn't rule until sometime 2015, maybe even 2016, I'm going to be subject then to the penalties for those years. Whether this gets expedited treatment because it is such a major issue and it's of national importance, we'll see. But the federal courts move at their own pace.
So you're thinking maybe June 2015 we have some guidance from the Supreme Court on this?
Yeah, I could
right.
see that.
Okay, well, great, thank you. All right, I do want to jump back and talk about a few of these FAQs. We're running short on time, and I do want to turn things over to Terrell in a timely manner. So I'm going to skip over some of these, and happy to discuss these afterwards for some folks. The other point I would make, just to James' point about preparing, for those of our clients who have actually started looking at this, which are not as many as I would have suspected. This is an implementation process that has taken months. I mean, this isn't just something where you flip the switch. There are a lot of questions to ask, decisions to be made. No two employers are coming down the same way in terms of how they implement. So don't wait till December, and definitely don't wait till the decision if you intend to move forward rather than roll the dice. All right. I just want to, the IRS released or quite often participates in a forum with the American Bar Association where they are posed questions about certain areas of the law, and they provide feedback or thoughts on how they interpret the outcome in that situation. The IRS had a meeting with the ABA in May of this year and just recently released a transcript of that meeting. And there are a few tidbits that came out of that transcript relating to the Affordable Care Act, specifically the employer mandate. You might argue that none of these are new results. I mean, it's all consistent with the statute, you would probably say, but some of them were fact-specific, and it was the IRS's perspective on a fact-specific situation. So while they don't have binding legal effect, it is illustrative in some manners. So I'm going to only highlight a couple of them here, maybe one or two. The first dealt with a question posed to the IRS that was, what if we have an individual who is hired in and is pursuant to an employment contract and is scheduled to work 40 hours a week, but for a distinct period of time, let's say 6 months. So if we're using a 12-month measurement period, while that individual is going to be full-time for the 6 months they're there, measuring it out over 12 months, they're unlikely to be full-time for that entire stretch because their employment's going to terminate halfway through. Do we have to treat that individual as a full-time employee, meaning we must give them coverage no later than the start of the 4th month following hire? Or can we treat them as variable hour and measure them over 12 months? The IRS reiterated once again that expected length of employment cannot be taken into consideration when characterizing an individual as a full-time employee or a variable hour employee. The only thing you're allowed to consider is the expected work schedule and the expected hours that they're going to work over that period. The only exception to that rule would be for a seasonal employee, where you can consider, if that individual is seasonal and is working for a period of time of 6 months or less, you can take that into consideration, categorize them as a variable hour employee, and measure them over 12 months, meaning they likely wouldn't qualify for coverage. That's a very narrow scenario, though, and we're not going to go into the details of seasonal employees here, but just make sure that if you're relying on that approach, you fulfill the parameters of a seasonal employee. I'm going to skip over that one, and I do want to focus on one more before I hand it back over, and that is a question that was posed to the IRS specifically about on-call employees. And this specific fact pattern dealt with a nurse who is paid $47 an hour while working, but is required to be on call during a variety of times in which they're only paid $3 an hour, but there are certain restrictions on what they're doing during that time. So they have to be close to home and they can't consume alcohol, which is a pretty serious restriction, especially if you're on call on a Friday night or the weekend. So the question posed to the IRS was, during that period of time, do we have to count those on-call hours as hours of service? And if so, can we only credit them with a partial hour of service because they're only being paid $3 an hour rather than $47 an hour? The IRS said no, because there are substantial restrictions on that individual's activities. That is considered an hour of service, and because they're being paid, that is considered an hour of service. So either one of the two could render that an hour of service, and as a result, in these instances, the employees need to be credited for those on-call hours as well. Also, the IRS clarified that even if you are only being compensated partially for an hour of service, there is no provision in the law that allows you to credit an employee with a partial hour of service. An hour of service is an hour of a full hour of service, no matter how much or little you're being paid during that hour. Notably, I know this question has come up a lot in the context of paid time off and specifically disability leave. So the IRS has said an hour of service is any hour of service for which you're paid or entitled to pay, which would include disability leaves when you're being paid pursuant to some sort of long-term disability policy. So one question we've received a lot from our clients is, well, if I'm only paying them 60% of their average pay when they're on disability leave, can I just give them 60% of the hours of service that they would otherwise be entitled to for that period of leave? I discussed this previously with the IRS informally, but I think that this answer confirms that conclusion, that the answer is no. If the individual is entitled to a pay for that period, regardless of whether it's full pay or partial pay, they are required to be credited for a full hour of service during that time period. Now, this has pretty significant and broad-reaching implications that cut across both benefits and into ADA requirements and disability leave, because I know that a lot of folks would keep individuals who are on disability on their payroll for a long period of time and potentially on their benefit plan, or cut them off of their benefit plan. But now what this means is that if those individuals, they would keep them on because of ADA considerations. What this now means is that any individual who remains on disability leave, if they're being paid pursuant to some sort of long-term or short-term disability policy, the likelihood is that you would have to compensate or treat that individual as actually working during that period of time and extend them coverage accordingly under the Affordable Care Act's employer mandate. went over my time here, and I did not get to all the on-call questions, but that was due to the unexpected and inconvenient development out of the D.C. Circuit Court. So thank you all for humoring us on our tangent there. But hopefully it was helpful, and I'm going to turn it back to either Jonathan or directly to Terrell.
Terrell, you want to take it from here?
Okay. All right. My name is Terrell Bagwell, the president of WorksTime, and I know Ben Connolly very well, and Jim, I've never met you, but I appreciate the comments that you all made about employers procrastinating and just rolling the dice and thinking that things are going to go away. We had our program up and running. I'm sorry you can't see it, but it's a program that automatically takes all the rules that on the eligibility and the measurement period, administration period, and stability period, and puts them in 300,000 lines of code, and we upload information from the employer, and we basically do all the heavy lifting, and the employer really doesn't have to get down into the weeds. So we developed this program started January 3rd of last year. Now, the very first and most probably wisest thing that we did is we hired Ben Connolly as our attorney. And Ben has been extremely helpful in helping us sort through all the rules, making sure that every line of code that we wrote, every time that they made a change, making sure he was available to help us understand that. And what we saw is, of course, July 2nd, June of last year, our program was up and running, ready to go, starting to load data and onboarding cases. And then all of a sudden came July the 2nd, and the employer mandate was postponed. So consequently, employers then thought that, okay, well, we've got a free ride now. And of course, I'm thinking that I had invested hundreds of thousands of dollars into a program that was going to not be useful for the employer. And then later on in the week, I realized that that really wasn't true, that it was just lifted, that you still have to measure for July for 2014 to be compliant 2015. And to Jim and Ben's point, that hasn't changed. And it would be, to Jim's point, probably at a minimum of next year in June, if it even got through either the Congress or the Supreme Court, that it would change. And so we are in hopes that employers will do as Jim and Ben has suggested, and go ahead and start measuring, because the odds are against them that it's going to change, and the odds are extremely not in their favor that if it doesn't change and they haven't measured and they haven't enrolled the number of the employees that they're required to have enrolled by measuring in 2014, that you can bet if it doesn't change that the IRS is going to start administering those fines, because the exchanges has to be subsidized in some way if that doesn't change. And I just read a recent article that I ran by Ben the other day that the IRS is counting on $130 billion over the next 10 years, or $13 billion a year to fund the exchanges. Right now, the $13 billion is a guesstimate for 1 year. I just read an article that's now $16 billion that they need, and they intend to get that from employers' funds. Of course, if it all goes away, then it all goes away. But it's just insurance. It's just the same way that we all have to buy insurance, is that nobody wants to get sick or plan on getting sick or having an accident. But this is law right now. And until this law is changed, either, like I said, by Congress or like Jim said, with the Supreme Court, it's still law. And I agree with both. The odds of undoing this and the implications that it would have to the American people are pretty slim. Do we think that there's going to be some changes? Probably so. But in our guesstimate, that's not going to, it's because it's going to affect so many hundreds of thousands of people. So anyway, to promote my business here, WorksTime does all the work. It's very, very economical. I think we did an analysis for our customer the other day, and it ended up being, and we were able to bring them on board, ended up being 1/2 of 1 cent or a nickel per hour per employee to be able to implement a program that does everything for them and automatically notifies them if they're out of compliance. And so for that kind of price versus $166.67 per month for every full-time employee that they're out of compliance is almost nothing. I mean, that insurance policy is just kind of a no-brainer. So, Ben, I'm going to turn the back, or Jonathan, back over to you. I just would like to emphasize to all the clients and as well as brokers and everyone else that's on this call is that not just because this is my program, but I had a comment the other day, 2,800 employee company that said, we don't need to do this. It's all going away midterm elections anyway. So we're just hoping that companies don't take a procrastinating approach and say, we're just going to wait and see, because if they wait and see and it doesn't happen like they would like it to happen, meaning it goes away and the fines start coming, their price for waiting and seeing could end up costing their company or cost them their company or costing their stockholders a lot of money. So, Jonathan, with that, I'll just turn it back over to you, and we can get things closed.
Thanks, Charles. And anyone, please feel free to type in any questions and answers you have for either Charles, Jim, or Ben. Thank you, Kelly. Kelly made a comment and said, Ben and James, nicely done, especially given the time constraints to talk about the new case. I'll start it off with one question, and that is, okay, I feel like this new ruling, even though another court did the opposite ruling, is going to cause some agents and employers to say, okay, I really don't need to do anything. I was putting things off. I was waiting to see what happens 1/1. Are the fines really going to go, and are they going to be delayed for employers? And now, the subsidies might be thrown out, and this could affect employers in federal states, whether they have to offer coverage or not. Should I just sit back, not worry about eligibility rules or complying and see what happens? And to Jim and Ben, what's your response to that?
Yeah, I can jump in here. I think we've seen some of these sort of false starts before, both with the 2012 Supreme Court decision, with the later 2012 election, and with some of the other challenges along the way. This one could really cut either way. If I had to put, I think certainly without a doubt, to Jim's earlier point, most employers will still be impacted by the law even if this ruling stands. Even beyond that, I think that it seems unlikely that this ruling is going to be upheld in the long run. It could go either way. It really just comes down to statutory interpretation by probably ultimately the Supreme Court justices. So what I think the outcome will be doesn't really matter. What matters is the opinion of 9 justices or 9 folks that sit up in Washington, D.C. So I don't think you can count on that definitively, that result. To Jim's point and to Terrell's point, I think you still have to proceed at this point, assuming that the employer mandate will be in effect.
Yeah, and the other thing to consider, too, from a more practical and pragmatic point of view is, what's your competition doing? So even if you feel that, the Supreme Court, they're going to rule in favor of this, I'm not going to have to worry about the employer mandate. If your competition is nonetheless offering compliant, good, quality health care to the employees, and you're competing with them for those employees and in the same pool, it doesn't really matter what happens in this particular case. You're going to want to make sure that you're keeping pace, with your competition. So, sometimes I'll see clients get so wrapped up and involved in the cases that are going on or the legislation that's going through. And you have to remind them, look and see what's going on in real terms. I mean, even if this case ultimately is upheld, or this ruling is ultimately upheld, what's going on within your industry? And if your competition is moving forward regardless because they're finding that it's giving them a competitive advantage to have good health coverage and it's affordable to the employer, that's where you're ultimately going to be driven anyhow.
Yeah, and I think, Ben and Jim, you could share your opinion, but I look at this as, as these things happen and it creates a little bit of a chaos and confusion and things like this, it's a great opportunity for agents, and brokers to really differentiate themselves and to really dive deep into, the ACA and be that, that I would say the guide for the employers, because right now there's not a lot of education out there for employers. What is your opinion for those agents who kind of say, well, I kind of understand the law, I have a good understanding of it, so I don't really need to dive deep into it. I'll just wait to also see what happens.
I think as an agent you want to be proactive, because the role of the broker slash agent is evolving. It has been evolving for probably the last 10 years or so, but with the Affordable Care Act, it's now more than ever evolving into the role of consultant. And many employers look to their brokers as their source of good information, and looking at the broker as a trusted advisor. So as such, you ought to embrace that role and be a little forward thinking on these issues. I often receive questions from colleagues. I just have one today. It's on the retirement side, but it's from a broker who isn't necessarily being as proactive, and it's coming through, and it's clear that they aren't. So I think the brokers who are ahead of the curve on this, who are keeping themselves informed, who are becoming certified, going through the certification process, really differentiates themselves. I find it much easier to work with the brokers who are certified and understand this stuff, and we, jointly represent various clients. But I think that's a good point. You want to be progressive-minded on this.
And Jim, you answered one of the questions. One of the questions was who is educating the employers on all the procedural regulations that they must comply. Insurance agent, insurance carrier, payroll company, or are there training classes out there for employers?
Sure. I mean, employers, the certification, the CRIS program, for example, that's not just limited to a broker. Individuals within employers and the HR departments can go through the certification process. There are a lot of online webinars and webcasts. So there's opportunity out there. It's just, I think there has, because of all the false starts and the government pushing back certain implementation deadlines, there's been a little bit of complacency out there. But I think at some point, and I believe we are at that point, where 2015 is 2015, 2016 is 2016. I don't see those deadlines being pushed out any further. They almost cannot, because economically it's already created a problem. From an actuarial point of view, the Affordable Care Act is already in the hole because there has been 1 year of missed revenue from the employer penalty.
Also, a question was, can Ben repeat how an employee out on disability, how this affects the hours being counted by an employer?
Yeah, that's a great question, and Jim probably has an interesting perspective on this as well. And the way that they did this in terms of defining hours of service is a little fishy, in that they referred to another existing law, but their reference was carved up and narrowed in some respects. So we've been looking at this quite a bit, but I think what's telling is that I talked to one of the regulators who drafted these employer mandate rules, and her perspective was that the intent was that payments, even disability payments, even if by a third-party payer, be counted as hours of service for those purposes. So again, I can make an argument to the contrary very easily, actually, based on reference to another law, but I would be remiss to contradict the views of a regulator on this issue.
And from a practical point of view, what that means then is, in implementing this, you want to really make sure you understand how the disabled employees are treated, because as Ben had mentioned earlier in the program, some employers have periods of time where you're considered disabled active, so you're accruing benefit service, for example, under the retirement plan, or you retain your coverage under the health plan and are eligible for whatever other employee benefits that the employer provides while the individual is disabled active. But then they become disabled inactive, so that they're disabled, they're under the long-term disability, but they no longer accrue benefits. You want to make sure that the verbiage in the plans and whatever policies you have covering this and the way that those hours might have to be counted for purposes of the Affordable Care Act, you would make it clear that they still are not counted, though, for purposes of benefit accrual under your other plan.
And one of the next questions is, what's the liability for the agent to advise on these matters? We are not attorneys.
Yeah, that's a really good question, and that's something we're going to be addressing in future programs, one of them being HAFA's program in October down in New Orleans, and that's exactly how should the agent broker protect themselves. One of the things that I would say, and I wrote a piece on this last month, and that is protect yourself, protect your employee, enter into an engagement letter. And in that engagement letter, spell out exactly what you are going to do and what you are not. And if you are not comfortable consulting on some of the, I'll call them quasi-legal issues, because when you're talking employee benefits, everything potentially could be viewed as a legal issue. But if you're venturing into the area and you're not comfortable making the call as to how the hours of service ought to be calculated, or some other legal issue, spell that out. That's not what you're there for. You're going to help them, your client, find the appropriate coverage for their needs. What you will not do is you will not do X, Y, and Z, and really spell it out as to where you're not. Because if you don't, you could, at worst, be viewed as engaged in the practice of law, which means there is ultimate liability. And at best, you would be held to a professional negligence standard, and if you miss it and you give them bad information, you're going to be held liable and potentially have to pay damages that could be, far in excess of the fee that you earn on the relationship.
And Jim, I think you partially answered this question. What's the effect on them, meaning the IRS, not collecting fines from employer mandates for 1 year, and why is that important? Can you explain the impact on how ACA is funded or underfunded, specifically for agents who think the fines may disappear?
Yeah, I mean, the fines are critical, because what the fines are is it's basically the employers who decide not to play, they decide to pay. They are, in essence, through this penalty, paying back the federal government some of the subsidy that the federal government provided to the employer's employees. So that's how they kind of work together. Now, I would suggest that the employer penalty, I don't think it, would be going away other than, with not taking this case into account. If the individual asking the question was saying that there's rumors that the penalty may go away in the future due to legislation or something, I don't see that. If anything, I see it as getting greater, the penalties going up. So that's one thing that in consulting clients on this, whether to pay or play, you have to remind them that there's nothing that says the penalty is going to stay at the level that it currently is. As a matter of fact, there is a built-in escalator, and then we could see legislation in the future where it says, this is just way too expensive. We need the employers to pay the federal government back even more than what they're paying. Because right now, the subsidy, what the employers pay to the federal government by way of shared responsibility, does not cover the actual subsidy that the government is paying then to the employer's employees.
Hey
But
Charles,
Jim,
can I throw a question at you, Charles?
Sure.
And the reason why is I think what Jim just covered, you really don't hear being talked about too often, in the industry is, this is the fines fund the ACA, and without the fines, you don't have coverage. I know you have your technology works time actually is, when you first showed it to me, I thought it was one of the coolest things. And if I was still a practicing insurance agent, I haven't been in a long time, I'd be using that as kind of a competitive edge with all my employer clients. It's kind of like, hey, you don't have to worry about fines, compliance. I've got everything taken care of. Are you finding, agents receptive and employers receptive to saying, hey, we realize the fine is here, and we don't want to have to manually calculate this, and we want to put in some kind of technology so we don't have to worry about getting fines? And is it going one way or the other, or do you have some agents and employers who really get it and say this is the winning solution, and others who, are just kind of putting their heads in the sand and waiting to see what happens?
Well, thanks, Jonathan. That's a multiple question. We're not seeing very many anymore. I mean, early on, we saw some people that thought that they could do this by an Excel spreadsheet, but that pretty much went away. What we're seeing more of, we've put on more business, and we're almost at 300,000 employees now, but we've put on more business in the last 3 months than we, and our system was up and running June 2nd of last year, because employers are, as you put it, getting their heads out of the sand. They're understanding the severity of the penalties and how easy, and we're explaining how easy that it would be to have a penalty. And I'll just give you one example that Ben helped us, I call them landmines, uncover the other day, is that we have clients that are saying, well, we will just wait until December 31st and measure back 6 months, and whoever qualifies, we'll go ahead and get them offered coverage, and that will be okay. And so Ben enlightened us that you can do that okay, but you have to get those people offered coverage that qualify before the first pay period in 2015. So if you had 100 people and your first pay period was January the 2nd, you better have something in place to get some documentation, because that's your time frame. Or if it's January the 15th, then maybe you have 2 weeks. But that's one of those landmine kind of little rules out there that employers really don't understand. Most brokers, unless they're really deep down in the weeds, which is our job, is to get down in the weeds and discover and ask Ben all these questions. One of the other things I'd like to point out, and I don't know, I know, Jonathan, you were in this meeting. I'm not sure if Ben and Jim was last year at your conference, and I asked the IRS agent about two things. One is, what's the new word of offer? Because in the old days, you gave a person a packet, and if they brought it back and signed up, they did, and if they didn't, they just didn't have coverage. Well, his comment was you have to have some documentation during the time frame that person is eligible and be able to prove that to the IRS. But the other thing that I asked him that was really interesting is how about the policing of the fines, how they were going to go about looking for people that were out of compliance. So that was back when it was still 95%. And because I could just see, okay, they zoom in on somebody that's 94%, and all of a sudden here's this big fine. And so, Jonathan, if you remember, what he said was, and no disrespect for the gentleman or anything like that, but what he said was is that they were not treating these fines as fines, or they were not treating the income as revenue. And I'm thinking, Internal Revenue Service? That didn't make a lot of sense to me, but that's what he said. Then he went on to say that they were treating this as discrimination, that they were looking for employers that were blatantly not measuring, not offering coverage when they were supposed to, and just cherry picking who they wanted to offer and not really caring whether they were in compliance or not. So I think when the fines start, that's where they're going to start first. It is for the companies that have just done nothing, just anticipating that it may go away or that they won't get caught. And that's going to be very expensive for some companies.
Thanks very much, Terrell. And barring any further comments from Jonathan, I think we probably ran a little bit over today, so I think we're going to wrap this up, and I'll pass it back to Jonathan to take us home.
Hi, everybody. Thanks so much. Actually, I'm not Jonathan, as you can see. I've stepped in his place. He had a prior commitment, so I'm coming in to close this up. There's a lot of questions on this webcast, and I want to let each and every one of you know that we will be conducting another session next week as this unravels and have more details for you to come. There's a lot of questions that I'll forward to the faculty and try to get answered. Appreciate everybody's time for sticking around. This was a very robust conversation and a lot to be had and learned, and thank you all. Thank you, Ben, thank you, Carol, and James for jumping on the line late for us, James. And again, we'll be sending out an invitation. Keep a lookout for that, and have a great afternoon, everyone. Thanks so much.